In this lecture, we shall attempt to solve one essay question in constitutional law. The question we shall discuss in this lecture is a question that falls under the constitutional law of Ghana. The question reads as follows. With the aid of decided cases and other relevant authorities, critically discuss the prevailing position of the law pertaining to the justiciability or otherwise of the directive principles of state policy contained in Chapter 6 of the 1992 Constitution of Ghana. With the aid of decided cases and other relevant authorities, critically discuss the prevailing position of the law pertaining to the justiciability or otherwise of the directive principles of state policy contained in Chapter 6 of the 1992 Constitution of Ghana. Now, before you begin solving any question, especially if it is an essay question, there are a few tips that you must bear in mind. One is that you must read over the question sufficient times as will be enough to enable you understand the question. Read the question carefully and ensure that you understand the requirements of the question. And by saying you understand the requirements, make sure you understand the key issues, the legal principles, and any specific instructions provided. The next thing is that after you have understood the question, plan your response. Plan your answer to the question. And then make sure you begin with a very strong introduction that will create a very good impression about the person answering the question. In your introduction, there are a few points you should note. Make sure that you are concise, you are clear, and you have presented the main arguments that you are going to present in your answer. They should feature in your introduction. The main arguments you intend to make, you can let them feature in the introduction so that the reader knows that you know the answer. Also, structure your essay effectively. This is a very important step if it is an essay question. Structure your essay if it's into 4 parts, 5 parts, and make sure that each part contains a different point or argument. So structure your essay effectively, divide your essay into coherent paragraphs, and make sure that each paragraph or point contains a separate point or argument. Next one is that when you begin writing, develop strong arguments that will be backed by relevant legal authorities. If there are case law, let them feature. If there are statutory provisions, let them feature. And you will show scholarship by showing counter arguments, even if it's the position of the majority, and there is a view of the minority which you think is worthy of commenting on. You can bring that view to let the examiner know that you are aware of differing opinions. And then in your conclusion, summarize all that you have said. So the goal is that tell them what you are going to say, you say it, and then tell them what you have said. Remember to structure your essay, give different paragraphs, give different parts, and make sure that each part, as much as possible, contains a separate argument. So the question once again, with the aid of decided cases and other relevant authorities, critically discuss the prevailing position of the law pertaining to the justiciability or otherwise of the directive principles of state policy contained in Chapter 6 of the 1992 Constitution of Ghana. Before you begin answering this question, it means that you must have already learned and studied about this topic. So it's not going to be another lecture on this topic. So this is how a good answer will look like. So this will be the introduction. And I read. This question raises for discussion the enforceability or otherwise of the directive principles of state policy. Remember what I said, that you tell them what you are going to say, you say it, and you tell them what you have said. So let's look at whether we are going to tell them what you are going to say in our introduction. In this essay, I shall rely on the cases of New Patriotic Party versus the Attorney General, 31st December case. New Patriotic Party versus Attorney General SEBA case, and the National Lotto Operators Association versus National Lottery Authority. In the first part of this essay, I shall explore the reason why the question has arisen related to the enforceability of the directive principles of state policy. In this part, I shall also discuss the 31st December case in which the holding of the majority was to the effect that insofar as the directive principles of state policy are contained in the Constitution, they are enforceable and justiciable. In the second part of this essay, I shall discuss the SEBA case in which the majority decision was to the effect that the provisions contained in Chapter 6 will only be enforceable if the provision contained in Chapter 6 is replicated in another part of the Constitution that creates an enforceable right. In the third part of this essay, I shall explore the seeming conflicts, the seeming conflicting position of the Supreme Court in the 31st December case and the SEBA case. In the fourth part, I shall discuss the lotteries case, in which case it was held that whenever there is an issue about the enforceability of the directive principle of state policy, then the discussion must begin from a presumption of justiciability, unless same is rebutted. Unless same is rebutted by another provision in the Constitution. The fifth and the final part of this essay shall conclude the discussion. So if you look at this essay, our checklist, what do we say? That we must have clearly defined matters. We must have a good structure. You can see we have in the first part. We have in the second part. We have in the third part. We have in the fourth part. And we have the fifth and the final part. This will be good for you so that in case you even forget or you get overwhelmed when you're answering the question, you can refer to the introduction and it will let you know where you have to continue at. Remember, you tell them what you are going to say, you say it, and you tell them what you have said. So in this part, we have told them what we are going to say. And we can proceed. So we now proceed to the next part. Say it. Remember, you tell them what you are going to say, then you say it. The next part. To start with, we are about to say it. To start with, the directive principles of state policy as contained in Chapter 6 of the 1992 Constitution are intended to be a guide to the entire citizenry, Parliament, the judiciary, president, council of state, political parties, all persons in applying or interpreting the Constitution of Ghana or any other laws. In its quest to serve as a guidance, the directive principles of state policy embody a collection of objectives, including but not limited to political, economic, and educational objectives. An example of an economic objective is as evidenced in Article 36, which enjoins the state to take the necessary action to ensure the maximum rate of economic development. The state is further enjoined to take the necessary steps to ensure the maximum freedom and happiness of every person in Ghana. With respect to educational objectives, Article 38 provides that the state ought to provide educational facilities at all levels and in all the regions of Ghana. To the greatest extent possible, this is to be made available to all citizens of Ghana. The question is, what is the import of all of these? We are demonstrating to the examiner that we know what directive principles of state policy means. So we shall continue. It is worth re-emphasizing that Article 34 requires Parliament, the President, and all persons to be guided by these objectives in interpreting or enforcing the 1992 Constitution of Ghana. So this is just demonstrating to the examiner that we know what we mean by directive principle of state policy. Now let's go back to our introduction and see what it says. We'll discuss the first part. It said that in the first part of this essay, I shall explore the reason why the question has arisen related to the enforceability of the directive principles of state policy. So far in our first part, we've only demonstrated what the directive principles of state policy are. We now have to answer the question, why is there any issue about whether it is justiciable or not? And this is where that portion begins. The mind-boggling issue which has plagued the minds of legal scholars is in relation to the constitutional status of these directive principles of state policy, whether they are justiciable or not. This uncertainty is predominantly born out of the language of Article 34, which only provides that the directive principles of state policy are only supposed to guide citizens, the President, Parliament, and all persons who interpret or enforce the Constitution. It does not state emphatically that they shall not be enforceable by the courts. In other jurisdictions such as India and Nigeria, it has been clearly stated in their national constitutions that the directive principles of state policy are not subject to be enforced by the courts. According to the Committee of Experts of the Directive Principles, according to the Committee of Experts who drafted the Constitution, the Directive Principle of State Policy is to serve as a barometer to measure the performance of the government. It is the loud silence of the Ghanaian Constitution on this matter that has sowed a seed of uncertainty in the minds of scholars. The uncertainty surrounding the enforceability of Chapter 6 is further accentuated by the fact that in the report of the Committee of Experts that drafted the 1992 Constitution, it has been stated that, quote, the principles shall not of and by themselves be legally enforceable by any court. I'll take that portion again. The uncertainty surrounding the enforceability of Chapter 6 is further accentuated by the fact that in the report of the Committee of Experts that drafted the 1992 Constitution, it has been stated that the principles shall not of and by themselves be legally enforceable by any court. Quote. Thanks. Now let's go back to our introduction. What did we say we discussed in our first part? Said in the first part of this essay, I shall explore the reason why the question has arisen related to the enforceability of the directive principles of state policy. At this point, look at the point that we have made. The point we made is that the people that even drafted the 1992 Constitution, they themselves mentioned that the principles shall not of and by themselves be legally enforceable by any court. Meaning that those who even drafted are saying that Chapter 6, they are not supposed to be enforceable of and by themselves. Meaning you are making progress in addressing the first part. And I proceed to read the answer. Against this backdrop, it has been argued that the very people who drafted the Constitution did not intend that the provisions in Chapter 6 would of and by themselves be legally enforceable in any court. It must be pointed out that this opinion of the Committee of Experts, which is evidenced in their reports, was not adopted by the Consultative Assembly, and for that reason, it is not reflected in the 1992 Constitution. In other words, the opinion of the Committee of Experts that the provisions in Chapter 6 ought not be enforceable by themselves is not embodied in the final draft of the 1992 Constitution. For this reason, the Constitution is silent on whether the provisions in Chapter 6 are of and by themselves enforceable. Let's go back to our introduction again. What did we say we discussed in the first part? We said that in the first part of this essay, I shall explore the reason why the question has arisen related to the enforceability of the directive principles of state policy. I think at this part, we have dealt with it. Because the paragraphs over here have mentioned that the Committee of Experts that drafted the Constitution, they put over there that the provisions should not by themselves be legally enforceable in any courts. But when they gave their draft to the Consultative Assembly, the second stage, they did not include any expression in the Constitution to say that the provisions in Chapter 6 are not supposed to be enforceable. So the final one that the people gave to the people of Ghana, it didn't have any statement that the provisions contained in Chapter 6 will not be legally enforceable. So that appears to be the reason why there's even an issue about whether the Chapter 6 is supposed to be enforceable or not, because the people who drafted said it's not supposed to be enforceable, but in the final draft, we don't have it inside. So let me read this portion again. And in other words, the opinion of the Committee of Experts that the provisions in Chapter 6 ought not be enforceable by themselves is not embodied in the final draft of the 1992 Constitution. For this reason, the Constitution is silent on whether the provisions in Chapter 6 are of and by themselves legally enforceable. Notwithstanding the silence of the Constitution on the matter, the Supreme Court of Ghana has had the opportunity to explore this area of law and make pronouncements on the enforceability or otherwise of these directive principles of state policy. Now let's go back to our introduction and see whether you're on track. In our introduction, we said that in the first part, we shall explore the reason why the question has arisen related to the enforceability of the directive principle of state policy. Then we added, in this part, I shall also discuss the 31st December case in which the holding of the majority was to the effect that insofar as the directive principles of state policy are contained in the Constitution, then they are enforceable and justiciable. In other words, in the first part of our essay, we must also discuss the 31st December case. So let's see whether we're on track. So I shall continue reading. It appears we're on track. A New Patriotic Party versus the Attorney General, 31st December case. The crux of the plaintiff's argument was that the celebration of 31st December as a national holiday with state funds was in conflict with the letter and spirit of Articles 3, 35, and 41B of the 1992 Constitution, and therefore same should be declared as unconstitutional. It is worthy to note that the said Articles 35 and 41 are contained in Chapter 6, and therefore the Attorney General argued that such provisions which are contained in Chapter 6 are not enforceable. So what are we done at this point? What we've done at this point is that we have given the essential facts in the 31st December case that led to even the question about the enforceability of the directive principle of state policy. Because the plaintiff had anchored their case on Articles 3, 35, and 41. Meanwhile, 35 and 41 are in Chapter 6 of the Constitution. So the AG is arguing that those provisions are not justiciable. Of course, and the reason will be because he's relying on what the committee of experts had said. So we proceed, and I read. While Banforado GSC, who was in the minority, held that Chapter 6 is not justiciable, and that the GSC, who was in the majority, thought otherwise. According to him, the whole Constitution is a justiciable document, and if any part of it is not to be justiciable, the Constitution itself must expressly say so. To the extent that he has not seen anything in Chapter 6 or anywhere else in the Constitution which makes the provisions in Chapter 6 non-justiciable, then he would hold that the provisions are justiciable and therefore enforceable. Let me pause and discuss what you are doing over here. Remember, in the first part, in the introduction, what did we say? We said in the introduction that we are going to rely on the 31st December case and show how the majority decision was to the effect that insofar as the directive principles are contained in the Constitution, then they are enforceable and justiciable. This is what we said we'll discuss in the first part. So at this point where we have dealt with this portion, where we have told you what Banforado GSC said and what Adade for the majority said, it means that we have dealt with that particular provision. So this is where we can say we are now done with our part 1 of the essay. Because in part 1 we said that we will rely on 31st December to show that Adade GSC took the view that once the directive principles are in the Constitution, then they will be justiciable. So you're done with the first part. Let's go to our introduction, what will be in our second part. In the second part of this essay, I shall discuss the Siba case, in which case the majority decision was to the effect that the provisions contained in Chapter 6 will only be enforceable if the provision in Chapter 6 is replicated in another part of the Constitution that creates an enforceable right. There's more that we'll add to this when we discuss it. So let's come to the second part. So we're done with 31st December. Subsequently, and I'm reading, subsequently, the question as to the enforceability or otherwise of the provisions contained in Chapter 6 came up again in the case of New Patriotic Party versus Attorney General Siba case. In this case, the gravamen of the plaintiff's suits was that the Council of Indigenous Business Associations law, which mandatorily required indigenous businessmen to join a particular association, was in conflict with inter alia Article 21 and Article 37(2)(a) of the 1992 Constitution. Once again, since Article 37 is contained in Chapter 6 of the Constitution, it was argued the same was not justiciable. The Supreme Court ruled that the provisions in Chapter 6 are not of themselves justiciable unless they are read together with other enforceable provisions in the Constitution. Then they go ahead. To this end, when a provision in Chapter 6 creates a legal and enforceable rights as evidenced in Article 37 2A, such a provision would become justiciable and enforceable because the freedom to form associations is replicated under Article 21 1E of the Constitution. Therefore, the essence of the holding in the MPP vs. Attorney General CBA case was that the provision in Chapter 6 would be enforceable if and only if the provision in question is read together with another provision in the Constitution which creates a legal right. In other words, it is not every provision in Chapter 6 that is justiciable. The only ones that are justiciable are those that can be read with other provisions of the Constitution that create a legal and enforceable right. Again, the Supreme Court held that when a provision in Chapter 6 of the Constitution in itself creates an enforceable right, then that provision will be enforceable and therefore justiciable. So at this point, let's go back to our introduction and see what we have said. Our introduction, we added that in the third part of this essay, in the second part, we shall describe the CBA case, in which case the majority decision was to the effect that the provisions contained in Chapter 6 would only be enforceable, will be enforceable, if the provision contained in Chapter 6 is replicated in another part of the Constitution that creates an enforceable right. Let me add again. The Supreme Court held that if the provision in question in Chapter 6 in itself creates an enforceable right, then that provision shall be enforceable and justiciable. Shall be justiciable. So that is for our second part. What will be our third part? In the third part of this essay, I shall explore the seeming conflicting position of the Supreme Court in the 31st December case and the CBA case. Why are we saying this? Because there appears to be a conflict. Because 31st December is saying that Chapter 6 will be justiciable because it's in the Constitution. Meanwhile, CBA is telling us two things. That it will be justiciable if and only if it creates an enforceable right in itself, or if you read it in conjunction with another provision of the Constitution, it will be creating an enforceable right. So CBA is giving us two things. Whereas the 31st December is saying that every provision in Chapter 6 will be enforceable. CBA is making it look like there are some that will not be enforceable. Then the only ones that will be enforceable are the ones that if you read in conjunction with another provision, they will create an enforceable right, or they create an enforceable right in and of themselves. So let's go to our third part and see what we said over here. Third part. It might be helpful to draw out the seeming conflicting decisions of the Supreme Court in the matter. It will be recalled that in the 31st December case, another GSC stated that the whole Constitution was justiciable. Impliedly, there was no part of the Constitution which was not justiciable, and therefore Chapter 6 was justiciable. On the other hand, Bamford Addo GSC in the CBA case held that it is not every provision in Chapter 6 that is enforceable. According to her, it is only those provisions of Chapter 6 that can either be read together with other provisions of the Constitution that create a legal and enforceable right, or the provisions in Chapter 6 that are enforceable in and of themselves as creating enforceable rights. So let me say that portion again. It might be helpful to draw out the seeming conflicting positions of the Supreme Court in the matter. It will be recalled that in the 31st December case, Adade GSC stated that the whole constitution was justiciable. Impliedly, there was no part of the constitution which was not justiciable, and therefore chapter 6 was justiciable. On the other hand, Bamford Addo GSC in the Siba case held that it is not every provision in chapter 6 that is enforceable. According to her, it is only those provisions of chapter 6 that can either be read together with other provisions of the Constitution that create a legal and enforceable right, or the provisions in chapter 6 that are enforceable in and of themselves as creating enforceable rights. That will be justiciable. So these are seeming conflicts. So now we can move on to the fourth part. What did we say we'll do discuss in the fourth part? So in the fourth part, I shall discuss the lotteries case, in which case it was held that whenever there's an issue about the enforceability of the directive principles, the discussion must begin from a presumption of justiciability unless it is rebutted. So let's go to the fourth part. And I read, final clarity was brought to the matter in the case of National Lotto Operators Association versus National Lottery Authority, in which case the Supreme Court once again had an opportunity to revisit the issue on the justiciability of the directive principles of state policy. In this case, that the GSC held that there is a presumption of justiciability of chapter 6. He reasoned that whenever the question arises as to whether the provisions in chapter 6 are justiciable or not, the starting point of analysis should be that all provisions in the Constitution are justiciable, unless there are strong indications to the contrary, as indicated in the text or context of the Constitution. Most importantly, he reasoned that there may be some provisions in chapter 6 which do not lend themselves to enforcement, and it is such provisions that would rebut the presumption of justiciability. In other words, so long as there is no evidence to show that a particular provision does not lend itself to enforcement, the courts are duty bound to enforce the provisions in chapter 6. This position appears to have been affirmed by the Supreme Court in the case of Izwami Manan versus the Attorney General. In this case, the courts, let me make it the Supreme Court, after affirming the position that the provisions in chapter 6 are prima facie justiciable, went ahead to hold that Article 40 of the Constitution is in and of itself justiciable. So, our fourth part, let's go back to our introduction. What do we say we discuss in our fourth part? So in our fourth part, we shall discuss the lotteries case, in which case it was held that whenever there's an issue about the enforceability of the directive principles, the discussion must begin from a presumption of justiciability, unless it is rebutted by another provision of the Constitution. I think we have dealt with that portion too as well now. That's what we have over here. I shall read that portion once again, the fourth part. Final clarity was brought to the matter in the case of National Lotto Operators Association versus National Lottery Authority, in which case the Supreme Court once again had an opportunity to revisit the issue on the justiciability of the directive principles of state policy. In this case, that the GSA held that there is a presumption of justiciability of chapter 6. He reasoned that whenever the question arises as to whether the provisions in chapter 6 are justiciable or not, the starting point of analysis should be that all the provisions in the Constitution are justiciable unless there are strong indications to the contrary, as indicated in the text or context of the Constitution. Most importantly, he reasoned that there may be some provisions in Chapter 6 which do not lend themselves to enforcement, and it is such provisions that would rebut the presumption of justiciability. In other words, so long as there's no evidence to show that a particular provision does not lend itself to enforcement, the courts are duty bound to enforce the provisions in Chapter 6. This position appears to have been affirmed by the Supreme Court in the case of Izuami Manan versus Attorney General. In this case, the Supreme Court, after affirming the position that the provisions contained in Chapter 6 are prima facie justiciable, went ahead to hold that Article 40 of the Constitution is in and of itself justiciable. So indeed, we are done with our fourth part. Let's go back to our introduction. What did we say we'll discuss in our fifth part? What do we say? The fifth and the final part of this essay shall conclude the discussion. So, conclusion. What is the final position of the law? Are the provisions justiciable or not? Is there a conflict in the decisions of the Supreme Court in the matter? So let's just make this one. In conclusion, the foregoing discussion clearly demonstrates that some scholars and legal commentators have opined that the decision in the lotteries case conflicts with that in the SIBA case, but there is no such conflict. So let me make it in conclusion. Some scholars and legal commentators have opined that the decision in the lotteries case conflicts with that in the SIBA case, but there is no such conflict. The two decisions rather corroborate each other rather than conflict. The two decisions converge in the sense that they both recognize that it is not all the provisions in Chapter 6 that are justiciable. The two cases further create exceptions, that is, if it is established, would make Chapter 6 not justiciable. For example, in the SIBA case, if the provision cannot be read together with another provision of the Constitution, which creates a legal right, then it will not be justiciable. In the same vein, the lotteries case, from the lotteries case, if there is a provision in Chapter 6 which does not lend itself to enforcement by the courts, then the presumption of justiciability would be battered, and therefore such a provision would be unenforceable. The two cases therefore do not conflict, but rather bring finality to the question of the justiciability or otherwise of the provisions in Chapter 6 of the Constitution. What is very certain is that the two cases significantly differ from the case of MPP versus Attorney General, the 1st December case. This is because in the 1st December case, it was held that all the provisions contained in the Constitution will be justiciable. However, as demonstrated from the lotteries case and the SIBA case, it is possible that some provisions contained in Chapter 6 may not lend themselves to enforceability. Right, so this will be the end of the answer. Let's do a check again. Remember what we said from the beginning. You understand the question, what do? Tell them what you are going to say So you have a very powerful introduction. Tell them what you are going to say. Then you say it like we did over here. Then if you look at our conclusion, you tell them what you have said. In our conclusion, you have in essence summarized everything we've said. We've described the CBA case, Lottery's case, and you've also discussed the 31st December case, meaning that we have told them what we have said in our conclusion. So this will be the end of our discussion on answering an essay question on the directive principles of state policy. Take note that this is only a guide. You may reduce it to suit the demands of your question and how much time you have to write. But remember the structure. You must have a powerful introduction, tell them what you're going to say it, and then tell them what you have said. This is where we shall draw the curtains for the essay question on the directive principles of state policy. Thank you.